Edwin, it's good to see you.
Wonderful to be with you here and wonderful to be doing this.
Now, Edwin, at the very dawn of this century, I mean, almost exactly 20 years ago, you had already been a judge for about 5 years, I think, in the High Court, and you shamed us all in your address, the Jonathan Mann Memorial Address lecture at the Millennium AIDS, the HIV conference in Durban, when you very squarely addressed what you describe in terms that I think none of us would ever forget as the shocking and monstrous iniquity of the way in which society and the law would have effectively condemned to death millions of people who were affected by that pandemic. And now, exactly 20 years later, having recently retired from the bench of the Constitutional Court, you've had now 20 years on the Supreme Court and the Constitutional Court. Your determination to make the law serve society seems to be undiminished. And I want to share some thoughts with you, if I may, and with others, of the ways in which this pandemic, which is preventing us from meeting face to face as we would have liked, is impacting on the way in which the law is working. And if we could, to think about ways in which lawyers can make it work better. Could I have some thoughts from you on that?
Well, Edwin, thanks very much for that introduction. It really is a joy to be with you. I want to just reflect for a moment on the way you've introduced me so generously, because of course, we thought at one stage in the mid-1980s, the British government thought, most governments in the Western world and in Asia and Australasia and America thought that the AIDS epidemic would become what people call a general epidemic. We thought that AIDS would be what COVID-19 has in fact now become. As it happened, HIV epidemiology took a very strange turn. It remained very much limited to what are sometimes called high-risk groups, people like myself, gay men or men having sex with men, injecting drug users, sex workers. But in Africa, of course, it did in the central and southern parts become a general epidemic. And we in South Africa have 7.5 million people living with HIV and AIDS, the world's largest sum of people. But the reflection really is, Edwin, that we paused for a moment in the mid-1980s when the world was very different. It was a more equal place. It was a less polluted place. The seas were less damaged by our voracious greed and pillaging. And we thought that we'd be brought to a standstill, and we weren't. People like myself, people in the gay community, were brought to a standstill. Black heterosexuals in Central and Southern Africa have been brought to a standstill. But of course, as you pointed out, we can't meet, we can't travel. London, Johannesburg, we are under a much more severe lockdown than you are. I'm planning for an arbitration appeal hearing in 10 days' time with 2 colleagues who are sitting with me on the panel. And we scoured the latest regulations. We're not allowed to meet. We have to do arbitrations by this medium, by Zoom or by WebEx or by WhatsApp. So it's a moment for us to rethink the way we practice law, the way we meet, the way we think of each other, because suddenly there's this terrifying dimension of human vulnerability, Edwin. I'd be terrified if you got it. I know that you've been exposed to life-saving challenges in the last couple of years, and you've been on treatment for them, which puts you at a very high risk. So I look at you, not as Edwin Glasgow QC, leading QC, former head of chambers, but I look at you as a humanly vulnerable person. We have taken practical steps in the latest regulations to try to address what you started off asking about, which was how we're going to practice law differently. In our regulations, and then in follow-up regulations that the Minister of Justice issued yesterday, they've eased the path to mediation and to arbitration. Terribly overduly, but at last it's happening. So regulation 13 of our regulations of 30 April make it possible for anyone seeking to sue the state to go a mediation or arbitration route. But of course, we should have been doing that when the AIDS epidemic beset us in the mid-1980s. Now, 35 years later, we are doing it, but at least it is now being done.
Can we, Edwin, on that topic, you're talking about arbitration and mediation, just a quick matter of fact, your remediation, the three arbitrators will sit separately, or will you all be in one room?
When we hear our appeal, this is a commercial arbitration, long scheduled, we'll each be at our homes, and the lawyers will be at their homes. The lawyers, the instructing attorneys, as you call them, solicitors, the briefed counsel, will all be severally spread out over Pretoria and Johannesburg and who knows, Cape Town. And then we'll convene, I think, on Zoom or Microsoft Teams, and we will hear a 3-panel arbitration appeal.
I think that let's just have one positive note if we can. I don't want to be too gloomy. One of the good things that we think may actually come out of this is, particularly in international arbitration, the days when 3 arbitrators fly around the world, halfway around the world in opposite directions, and meet in a 5-star hotel and spend quite a lot of money in order to have a directions hearing. I think they're past. I think that clients and your attorneys and our solicitors and clients are beginning to wake up to the fact that kind of thing is really quite unnecessary and disproportionate. And I suspect that one of the good things that may usefully come out of this, we were going to talk about how lawyers can change their habits to give a better service, is that we won't be doing that amount. I confess I have a little bit of reservation more about the actual conduct of hearings. I'm finding those, I confess, quite difficult. I'm finding particularly handling witnesses online more difficult. I suspect with your greater judicial experience, that's maybe easier, but trying to form a fair judgment of people when you're only seeing them on the screen isn't easy for those who have limited experience of actually sitting as judges. But there's a new dimension, isn't there? Because we are about to be hit with a tsunami of disputes that are already arising and which I think perhaps threaten to drown our legal systems, which are already trying to lay on what they call virtual hearings from their life rafts. And I'm thinking about what might loosely be described as force majeure disputes. We've got situations where individuals, corporations, and indeed states are legally committed by either commercial contracts or for lots of other reasons in public law to obligations which they are simply unable to perform and can't perform. And of course, common law and civilian law have different approaches to that. But my first thoughts are that there are going to have to be means by which they can be addressed, either by agreement or mediation. But some kind of a dispute resolution mechanism is going to have to be available for those hundreds of thousands of disputes, I suspect is no exaggeration, and a mechanism for dispute resolution which is not in the business of producing winners and losers anymore. What are your thoughts about that? Are you having those kind of claims in South Africa as well?
Yeah, we're certainly having thoughts like that, Edwin. Of course, there was a belief at one point that the Chinese system of justice sought to do these things differently, didn't seek an adversarial hearing, a list of, and there's some virtues in the way we do things, because we learnt the way we do things, as I think in the other Commonwealth and British Empire countries, from the Inns of Court and from London and from the courts in Edinburgh, which were highly adversarial, highly lawyer dependent, highly contestatorial. But there are better ways of doing things and of relieving people of the burdens of lawyers and finding resolution. And I think the dialogue that you referred to at the Bingham Institute between some very distinguished English lawyers was directed to that. And I believe that it will be productive. We have to. We simply don't have any choice.
I mean, it was bad enough. I mean, in some ways, there's nothing more annoying than having people like me who've made a living out of encouraging people to litigate for half a century, suddenly having a Pauline experience and saying we've got to all throw our wigs away and love one another and mediate everything. I know that can be really very boring, and I happen to believe in it quite passionately, but mediation isn't the answer to everything. But with this new flood of, and I mean, I think perhaps no exaggeration, tsunami of claims that we're going to get of, I use force majeure because I can't think of a better phrase for it, but the number of interrupted obligations through nobody's fault, that we do really have to think, don't we, about a dispute mechanism that is not about winning and losing anymore, because otherwise we are going to drown under them.
Yeah, I think that's right. And while there is a loss, as you say, because certain disputes actually need a winner and a loser, I think those are relatively rare disputes, where disputes perhaps about truthfulness or veracity or integrity in a person. Most commercial disputes aren't of that sort. So while there will be some losses in the new, of what we hope will be the new way of doing things, I think on the whole there'll be considerable gains, because one of the things you can do is to require people in before litigation. Our new regulation, unfortunately, doesn't go as far as that. It makes it optional, but you could require people to go to mediation first, or to explore mediation at least, which of course presupposes that you've got competent and skilled mediators on hand to see whether something, there can be something for each side in a mediated outcome. But it'll have to be required. It can't only be optional.
It's interesting to hear you say that. I mean, you've made your living as a judge largely in public law with the Constitutional Court. I mean, and I'm right, aren't I? It's 20 years. I think you were, the first 10 on and off in the Constitutional Court, but a solid 10 years in the Constitutional Court. Do you seriously see in the present climate, when there are going to be states are going to be unable to perform obligations which maybe they accept that they have because of the way things have happened, can you see mediation being a useful tool even in that kind of dispute?
Well, it'll have to be. We're having a debate in South Africa at the moment, because we're in a parlous state, worse than the United Kingdom. We had a sluggish, virtually static economy when this beset us, and we've now gone down several rungs on the ratings lists. But there's considerable talk, I believe also in government circles, of declaring sovereign defaults on significant debts owed to international institutions.
Yes.
And that'll have to be mediated. Of course, one of the difficulties is that our government, in my view, and I'm now entitled to express these views having stepped down from the bench 9 months ago, wrongly turned away from bilateral treaties for dispute resolution. I think those were very beneficial, and I think that regional and international fora are also very beneficial. But we're going to have to, and we're going to have to move very quickly to avoid a situation where governments just walk away from their obligations, and therefore walk away from the possibility of international assistance, which is contingent upon fulfillment of obligations.
Coming back to private obligations, coming back to the sort of law that you and I used to practice many years ago of commercial disputes, is your legal system still coping with that by means of virtual trials?
We haven't done enough of that, Edwin.
So what's happening to the cases? There must be a huge backlog.
Yes, enormously. Enormously so, and it's not a point of pride in our legal system. We've got well-functioning courts and poorly functioning courts, and in most courts simply enormous backlogs.
Is arbitration partly an answer for that? I mean, are you going to have to, a huge number of you've got some stunningly good arbitrators, a lot of your retired judges like you who've done a huge amount of arbitration. Are they going to be able to fill the gap that's left with to dispose of some of these
I
cases?
doubt if it can be filled, because again, we're talking adversarial,
Yes.
contestatorial hearings. But the premise of our whole conversation has been that there's going to be an absolute tsunami of cases. And in that case, retired judges and other skilled senior counsel and senior attorneys, solicitors won't be able to fill the gap, I don't think.
What about, you know far more than I do about this, but what about criminal law as well? I mean, we've now got a fairly frightening backlog. I think of something like 50,000 criminal cases. We, of course, still have trial by jury, which you don't at all, do you? No, the juries are completely gone for you. And it's almost unthinkable that you could have a trial by jury virtually, although you may have seen there have been suggestions by some very eminent responsible judges that you might be able to have a defendant who perhaps has a technical and unmeritorious defense consenting to trial by judge alone, but that's going to be very much scraping the surface. What are you going to do about your criminal trials? Are you trying to conduct any of those or deal with any of those virtually?
Well, we haven't yet, Edwin. The new regulations that the minister published has put a moratorium on the process. We're hoping to move down from, we were in lockdown stage 5, which is the highest until Thursday last week. Friday, we went into stage 4. The hope is that we'll be able to go into stage 3. But the difficulty, Edwin, is that our epidemic has been curiously quiescent until now. The British and the United States epidemics took off after the first 100 cases. Ours hasn't, but it seems to be taking off now. Our initial governmental response seems to have been very good, but there's disturbing information from the Western Cape of mass spread of contagion in the Cape Town townships.
In the townships.
That's a long way of saying that we don't actually yet know how we're going to be impacted. The minister, I think, issued his regulations yesterday on the premise that we were going to get down to stage lockdown 3 and lockdown 2 and lockdown 1. But it may be wrong, in which case we'd have to think. Of course, we have judge-only criminal trials. The High Court judges are entitled, and some senior magistrates, to invite lay assessors, legally qualified lay assessors, to assist them. But basically, it's a one-person credibility assessment and a one-person reasoning and outcome determination. So we don't have the considerable difficulty that the English jury tradition has.
But we still both have the same problem with commercial disputes and with public law. And at least from what you're saying, our mutual approach to commercial disputes, arbitrations are continuing to work. Now, you actually hear appeals. You have a slightly different system than our 96 Act. It is considerably easier to appeal an arbitration award, isn't it, for you? And in fact, you do quite a lot of arbitration appeals.
Well, in fact, I don't, because I've been busy with my other job, post-retirement job, which is my prisons inspecting role. But I'm now coming up to my first couple of arbitration appeals. But in our system, Edwin, it depends entirely on the parties' agreement. You don't have
entirely consensual. They've got to agree to it.
To an appeal, yeah. And I suspect that a lot of them don't, because arbitration appeals are relatively rare. It's sudden death. You live by the arbitrator, die by the arbitrator, and that's it. But of course, if you're two capacitated, relatively resourced parties, you envisage the possibility of an appeal, and then it ends there, barring gross misconduct.
The great Michael Mustel, you'll remember, said that the great advantage of arbitration is that the parties pay quite a lot of money to get the wrong result. And then you live with it. But arbitration for us is actually, as I've confessed, I don't personally enjoy it much because I find it a rather frightening medium to work in. But arbitration and the great arbitrators are still hearing sizable numbers of them on a daily basis. Yes. That does seem to be functioning. And as we were saying right at the outset, I think we may benefit from that because we may do it even more efficiently when people learn that it's not necessary to have these massive hearings certainly on sort of what we would call interlocutor matters.
Does your lockdown status allow in-person assemblies in hearing rooms?
Not at the moment. We're on the brink now that our Prime Minister is back at the helm. I'm not quite sure what advantage that is, but now that's the position at the moment. We're going to get an announcement, I think, within about a week as to the extent to which there is going to be a loosening up. At the moment, we're not allowed to all sit together, but in a way that doesn't. I finished quite a big international arbitration last week with everybody in separate rooms. And funnily enough, it ran for 8.5 hours. And I think by the time 2 or 3 hours, none of us was really conscious of the artificiality of it. And it worked quite well. And there's something to be said for encouraging that. Although I think that mediation is going to be better, although difficult, I find much more difficult physically to conduct. The other practical problem, Edwin, is that, of course, in an arbitration, you can have a professional administrator, and I think you need one, to put people into their separate rooms, to put the arbitrators into their room virtually during coffee breaks and things, and to bring people back together to organize. In mediation, you can't do that. So the mediator has got to be, even in domestic mediation, which I also do, but particularly in international mediation, where you may run for 20 hours or more in a big and complex thing with 3 or 4 parties. And the mediator has to have the IT skills to be able, him or herself, to be able to control that. And that's not easy. That in itself presents quite a few challenges. But it's working.
A whole set of new skills that we'll all have to acquire.
And may have to, and the next generation may have to learn it from us and carry on with, because I'm not sure that particularly in international work, there's going to be a huge willingness to go back to the massive expense of transporting people around and the expense of having everybody together in 5-star hotels.
Expense and environmental cost.
Yeah. Tell me something about, I didn't realize, the other work, the prison inspectorate. I mean, dare I ask, what is the state of South African prisons at the moment?
Not good, Edwin. We have the world's 12th largest body of incarcerated persons. We are 31% overcrowded. In the UK, you are 7% overcrowded, which is better than the international norm. About 1/3 of our total number of people in prison are awaiting trial prisoners, remandees. And COVID-19 is something that you definitely don't want. Is the sunset?
The sun is beautiful. It's over your shoulder at the moment. Doesn't matter. That's better.
Okay. So it's pretty desperate. We're watching what your prison inspectorate is doing, and I've been trying hard to get a release of prisoners. There's a 2-track intervention being sought to be made for remandees and for sentenced prisoners. And of course, the objective is not just a bleeding heart objective to get people out of jail who otherwise be at terrible risk of infection, but also to get the prison system off the burner, because personnel are also at risk if this thing takes off already. Yes. In Italy and Colombia.
Well, you really should follow our example on that, because we've got a lot to teach you. We just let a huge number of people out, and being British way of life, of course, we let the wrong ones out, but also being the British way of life, they were all extremely gentlemanly about it and immediately clocked back in again, although I'm not quite sure what the procedure was for claiming readmission rights. But so that's the English way of dealing with that. But it's quite worrying, isn't it, we're sitting as lawyers, we're playing a part in sending people, depriving people of their liberty, and then not honouring the obligation. I mean, it was that one old Durban resident, Gandhi, I think, didn't he say that the measure of a civilized society was the way it catered for its most dependent residents, its most dependent members? We've got the same, as you can probably heard about, with our care homes, because, I mean, shamefully, our Office of National Statistics thought it wasn't necessary to count the odd 1,000 or so elderly people who died, because they didn't really count in our numbers, which also reflects on the Gandhi principle a little bit. But we do have to think about looking after the people who either through old age or because of what we've done to them, are not able to look after themselves.
Well, we're going back to where we started, which was this whole thing of the fact that we are all terribly vulnerable. We're terribly vulnerable to contagion, to disease, to disability, and to mortality in the end, of course, all of us. But you're right, yeah, that's right. And of course, this pandemic has stopped us in our tracks, environmentally, in our mobility, and in our legal ways, which, as you said, has some positive results. One must look for them, and one must embrace them, and one must implement them.
And we can't go on for too long, but trying to come back to a positive, do you see now, back as a sort of practicing lawyer, doing your arbitration and other things, even in addition to your prison work, do you think some good can come out of this, to the way in which we can improve the service that we provide for society as well as for our clients?
Well, I think so, Edwin. We have to. Let me go back to something where I met you. I met you in advocacy training, the Gray's Inn scheme. Yes. That you started and implemented, and we met just over 20 years ago. Before that, yes. that speech that you started at the start of this dialogue, and that in itself was quite a revolution. That the idea that a young barrister entering chambers in London should be trained was I think back, quite remarkable. And of course now it's accepted. It's accepted around the world. The schemes that you and Tim Dutton and others introduced in London and at Keeble have gone around the world, Singapore, India, elsewhere. You've brought it to Malawi and to Botswana and to South Africa. So we have to rethink the way we do things, and I think that's a positive. The particular details of how we're going to improve ourselves as lawyers and improve our dispute resolution capacities as lawyers, and rethink ways away from the contestorial, gladiatorial ways of our past, have yet to be determined, but that we will have to find those ways is absolutely certain.
Well, maybe if it forces us to do that, some good will come out of it. But in the meantime, I know that the younger lawyers in my team, and I hope in yours, are going to be hugely grateful to have had the wisdom of your thoughts. It is lovely to be able to talk to you, even if only virtually, Edwin. And after all that you've been through, to see you looking so magnificently well after the massive contribution you've made, which would have exhausted any lesser man, even a totally fit man. It's lovely to see you. Thank you for the encouragement.
Wonderful to speak, Edwin. My only objection, lodged right at the end, is that this was less of a dialogue than you promised, but it's been a delight. Thank you.
Well, of course, we should never forget that our mutual friends, for reasons that are wholly now obvious to everybody, have always referred to you as Edwin the First and me as Edwin the Second, and now the world knows why. My good friend, bless you, and thank you for your thoughts. Bye-bye.
Bye-bye.